based on the challenges as applied to these particular facts, the constitutionality of the FAPA amendments was upheld.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today we're talking about a major New York Court of Appeals decision. I'm joined by Friedman Vartolo, Senior Appellate Counsel, Stephen Vargas. Why don't we start with the nuts and bolts here? What was decided?
There were two opinions issued by the Court of Appeals. Article 13 LLC versus Ponce de Leon Bank and Van Dyke versus U.S. Bank. They were two quiet title actions commenced by property owners under RPAPL Article 15 to cancel mortgages. There were appeals through the lower appellate courts. They both ended up, for slightly different reasons, in the New York Court of Appeals, the High Appeals Court. And in those cases, the state's highest court upheld FAPA's retroactivity clause as constitutional.
So this is a done deal. Court of Appeals declared that FAPA's retroactivity was constitutional. Is that correct?
Not exactly. The Court of Appeals' opinion that FAPA is retroactive to foreclosures commenced before the statute's December 30th, 2022 effective date resolves that particular issue. However, these two appeals involved as-applied challenges to FAPA based on particular FAPA statutes that were being challenged, as well as particular facts of the cases. The courts didn't address about half of the FAPA statutory amendments or even make reference to those other amendments in these decisions because they weren't relevant here. So there could be circumstances in the future where the courts reject a homeowner's attempt to rely on FAPA to dismiss a foreclosure or cancel a mortgage.
What you said regarding the as-applied language, right? Is that common? Was the court leaving a loophole here?
There's two types of constitutional challenges, generally speaking. There's a facial challenge to the statute, which is when you challenge that the statute in every context is unconstitutional. Any conceivable fact pattern, this statute is unconstitutional. As applied is a more targeted challenge. It's an easier challenge to make, frankly, because you're saying in certain circumstances, the statute is or is not constitutional. So here, the court said, based on the challenges as applied to these particular facts, the constitutionality of the FAPA amendments was upheld. But I think using the as applied language is notable because it does contemplate scenarios where a court presented with different facts could reach a different conclusion. I'm not saying that they will, but they don't foreclose the possibility of doing that, which I think is why it is notable that they acknowledge that these are as-applied challenges rather than broad facial challenges to declare a statute unconstitutional under all circumstances. And that's something that the servicing industry needs to be aware of based on the opportunity that may present itself given the as-applied language used by the Court of Appeals in the decision.
All right, Steve, thank you. I really appreciate it. Obviously, this is moving in real time. We're hitting this pretty quickly, so I really appreciate your insight and your recap.
Of course. Thanks, Adam.
Thanks for joining Steve Vargas and I in the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.